10, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0.
Hello. Hello, my friends. That's a Seinfeld reference. If you know, you know. Thank you so much for coming to spend part of your Monday, February 5th, 2024 with me. The jury is out on the Jennifer CRUMBLEY case, and I don't think they're coming back today. It's my gut feeling. So I thought, while so many of us are on verdict watch, I might as well entertain you for a little while. And I want to know what you're thinking about and how you're feeling about this Jennifer CRUMBLEY case. And I want to go over the jury instructions with you because the judge read the jury instructions so quickly and really without any feeling. They were repetitive because she had to read them out for each of the 4 counts, for each of the tragic young lives that were taken way too soon. And the more I think about this case, the more conflicted I am about this case. And that's why I don't think the jury's going to come back today. I don't think they can. I do not think this has to be unanimous. Remember, 12 people have to agree. And I just don't think they're coming back today. So I thought we could hang out for a little while together this afternoon. And obviously, if they do come back with a verdict, we will break to that to read the verdict. But I just don't think it's happening today. I don't think it's going to be quick at all. So many of you, and I see your comments, and we talked the other night about this. So many of you are conflicted. And I just think when it comes right down to it, that 12 people sitting in a jury room are going to have a lot to say to each other about this case, a lot. And I think that just as we are, when we did the poll the other night, it was so divided between guilty, 100%, 100% not guilty, or I'm on the fence, I have no idea. They are going to do a lot of talking. And if the jury is hung, it will be a while. They won't let the jury deadlock in one day, that's for sure. Yay, Shannon says she never caught a live before. Yay, congrats. Welcome, welcome. We keep it classy here. So for those of you who are just joining or maybe new to the channel, I am Melanie Little. I am a New York State licensed attorney. I've been practicing law in New York State and federal courts for 30 years. I'm now a recovering lawyer turned analyst, commentator, and YouTuber, apparently. I am also a mother of 5, and so this is not a neutral channel. I have a lot of feelings, I have a lot of opinions, and I'm going to share them with you. And that's what we do here, but we respectfully disagree, and we agree to disagree. And my moderators are the best on YouTube, and they police the chat like nobody's business. So there are no personal attacks, no bullying, I don't like foul language, so I don't use it on my channel because I have a lot of people who tell me they're so excited that their 95-year-old mother finally has a place to watch true crime because there's no foul language. So you know what? We're going to keep it that way. We like to be kind. We like to be classy because you know what? It's really not hard. It is really not hard. And that's what we try and do. So if you could refrain from any breaking news other than there's a verdict, and I'm going to keep that actually up on my phone to see what is going on. I know the jury came back with 2 questions today. And they really didn't mean a whole lot to me either way. The second question they came back with was they wanted to know if they were allowed to draw an inference that some people did not testify in the trial, such as the shooter, Ethan CRUMBLEY. And they are not. They are not able to draw an inference from people not testifying in the trial because if Ethan CRUMBLEY was called in to testify on behalf of either side, he was going to take the 5th, and his, hi, Kurt. Hello, Kurt. And his testimony would have been pretty worthless anyway. But I have a lot of, I'm really conflicted. I'm really conflicted about this case. I think it's a dangerous precedent. I think it is a slippery slope. I think, where do you draw the line between parenting and criminality. I have a big problem with that. So many of you told me to go watch the Miller hearing, which I did, and I wish I didn't. There was a lot of stuff in the Miller hearing that you cannot unsee or hear, and it was disturbing on a lot of levels. This mic stand is not my friend today. A Miller hearing is held anytime a juvenile is to be sentenced to life in prison without possibility of parole in a juvenile case. And so they put on a hearing to talk about the severity of the crime, the premeditation. And there were a lot of things that I discovered in that hearing that the jury, in this case of Jennifer Crumbley, will not hear. So those of you who did watch the Miller hearing, you have a completely different set of facts that this jury did not hear about. Yeah, thank you, Uncivil. Don't watch it. I'm like trigger warning to the nth degree. Kurt says, yeah, I haven't watched the Miller hearing because I didn't see the point as it relates to Jennifer Crumbley. I know so many people told me to watch it, so I did sort of watch it. And there were a lot of journal entries and text messages from Ethan to his friend that were chilling. But chilling to the level of, it makes you think, is there any way she couldn't have known that he was a psychopath, a sociopath? It just showed a whole new level of what this kid was thinking and how much of a psychopath, sociopath he is. And we're not hearing a lot about this in this trial. And I'm glad, because I think the verdict would be different. So I'm going to leave that there for now. Yes, Jules, exactly. The parents never saw the journal. The parents never saw the journal, and the parents never saw the text messages. So, my question is, should they have? And I think that each parent affords their teenager a level of privacy that they are comfortable with. And I told you that I do not read my kids' text messages, and I do not read my kids' journals, and I have 5 kids. I have 3 kids, 3 teenagers who are sick right now. They've all been passing around the same illness for an entire weekend. But I don't read their journals. I don't read their text messages. I afford them a level of privacy. I also have no reason to believe that they would ever commit a horrific mass shooting like this. And I don't think that any parent can grasp the severity of that, or even have any sort of foreseeability that their child would ever be able to do something like that. I bet if you go back and you asked Ted Bundy's parents if they ever thought that he was capable of doing what he did when he was 15, what they would say. Were there signs? Did they know? I mean, because that's what we're getting into here. We're getting into parenting, and we're getting into what she should have known based on what she should have seen or done, or violating his privacy. So that's a problem for me. And Kurt, I agree. The journal should not have been admitted. It's hearsay, irrelevant, and substantially more prejudicial than probative. The judge's ruling is its present sense impression can bite me. Yeah, she can bite me too. And I keep it classy. So we're just going to say bite my, there was no reason for that because Jennifer Crumbley never saw that journal. So I think it's a problem. But let's take a look together at the jury instructions, because we're going to get a little bit more insight into what it is that the jury is actually going to have to decide. And I transcribed them for you. And the jury was given a copy of the jury instructions to bring with them into the room. So let's go through the jury instructions, and then if there's no verdict, because I don't think there's going to be a verdict, I want to go back and watch the closings, or at least a portion of them. And then there's something else that I wanted to watch, which was Jesse Weber did a pretty good podcast the other day, and we can look at portions of that with regard to certain portions of Jennifer Crumbley's testimony. Because in my mind, the testimony that we played the other day from the dean of the high school was the most important testimony for me. And I think Jennifer Crumbley's testimony is most important. So everything else is sort of filling in the blanks, showing the video of the actual event. Kurt, I don't know what you think about that, But to me, that was highly prejudicial. She wasn't there. She didn't commit this horrific act. And I don't know why the jury had to see that. You can't unsee that. Once you see that, you're like, oh, well, I mean, if a kid could do something like this, of course his parents had to have known there was something wrong with you. My friends, I'm going to submit to you that 15-year-old boys can be withdrawn. They can be sad. They do not necessarily want to talk to their moms. I did not see any evidence that he actually asked his parents for help. I saw evidence that he may have texted that to his friend. I asked my parents for help. She's going to say he didn't ask me for help. So Ethan didn't testify. And those text messages, you're supposed to draw an inference that because he texted his friends, I asked my parents for help and they laughed at me. We're supposed to believe that. I mean, talk about hearsay issues, Kurt. Yeah, the video was also a bit much. I agree. But everybody has different parenting styles. And once we start as a society invading that and holding parents criminally liable by assuming what they should have known about their child, I don't see where it ends. I don't. So let's take a look. These are the jury instructions for Jennifer Crumbley as read by the judge, and they were a bit more repetitive than I have them here because in each count, remember, she's charged with 4 counts of involuntary manslaughter, 1 for each of the students. And so she repeated this for each individual victim. In each count, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecution must show each of the following elements beyond a reasonable doubt. Number 1, that the defendant, and remember, defendant in this set of jury instructions is defendant Jennifer Crumbley, not Ethan Crumbley. That the defendant Jennifer Crumbley caused the death of the victim. That is, that the victim died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. She testified the gun was locked up and it had that cable lock on it. So in addition to that, the jury has to find also that in doing the act that caused the victim's death, the defendant, Jennifer Crumbley, remember this is not Ethan, acted in a grossly negligent manner. And we're going to give the jurors the definition of what gross negligence is. The prosecutor asserts 2 different theories to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because she failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because she was grossly negligent. So they only have to prove one of those 2 theories, and the jurors do not have to agree on which theory it is. Some jurors could say, well, I feel that she's guilty because she failed to perform a legal duty. And some of the other jurors could say, oh, I think she was grossly negligent, and therefore that's why I think she's guilty. They don't all have to agree on the theory, but they do all 12 have to agree that she's guilty. Those theories are 2 different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. In each count, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of these elements beyond a reasonable doubt. So if they're going to go with the failure to perform a legal duty, theory, they have to agree to each of these 4 things beyond a reasonable doubt. Number 1, that the defendant, Jennifer Crumbley, had a legal duty to the victim. The legal duty to be charged here is one that is imposed by law. So there is a legal duty in Michigan, and I'm going to tell you what it is. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent their minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. So if both of these things are true, that's when it rises to the level of a legal duty. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Now, I'm going to submit to you that the evidence showed that she did not realize the extent of his mental illness. But let's just even put aside mental illness, because in the Miller hearing, they found that he was mentally competent and that he did not even have a diagnosis of any sort of psychopathy or anything like that. But even if she did know it, did she have the ability to control it? Could she have controlled it? Remember when they bought this gun for him for Christmas? They already had 2 guns in the house. And there also was no law in Michigan at this time that you had to lock your guns up. And I do not, and I've told you this before, I do not come from a gun-friendly state. I live in New York. I didn't grow up around guns. I don't own guns. Growing up, I didn't have friends who owned guns. And so while I may not be a person who is in favor of guns, I am in favor of the Constitution. And under our Constitution, people have a right to own firearms. Now, I got a lot of flack when I was talking about the Long Island serial killer case, and they found 297 guns in the basement of Rex Heuermann, the accused Long Island serial killer. And I said some flippant comment that was supposed to be funny, like, I mean, how many guns does a person need at 297 guns? And it wasn't my show, so I couldn't control the comments and delete them, but I got killed in the comments. Like, lady, what are you talking about? Under the Constitution, we can have as many guns as we want. I mean, people went nuts on me. So I tread very carefully when I talk about gun rights. Just because I don't agree with owning a gun or having a gun in my house with my children, it doesn't take away the right for other people to do so. This is not a case where a 5-year-old got a hold of a gun that was on a bed and shot his friend who was over to play. This is a 15-year-old boy who, based on the journal entries that I saw during those Miller hearings, this kid was going to do this no matter what. No matter what. And the jury in this case didn't hear a lot of that stuff. But he was on a mission to get this done, and he would have done it no matter what. And if it wasn't this gun, it would have been another gun. And if it wasn't a gun that the family owned, he would have found a way. He was on a mission. The second thing, that if they're going to go with the legal duty theory, the second thing that they need to prove is that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. 4, that the death of the victim was directly caused by defendant Jennifer Crumbley's failure to perform this duty. That is, the victim died as the result of defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. I want to know from moms, dads, parents of teenage boys, if you think that when your kid was a teenager or 15, I'm going to say boys for purposes of this illustration, if you had the ability to control them. Hey, Sarah, thanks for becoming a new member. And DK, thank you for being a member for 3 months. 15-year-olds are hard to read. My daughter started having signs of big depression. I could tell. She pushed me away, wouldn't talk. I kept at it from different angles. It was real serious. You can't give up. Yes, you can't give up. I agree with you. And I think that there was some testimony that when Jennifer Crumbleigh, oftentimes when you have these issues, D, tell me if I'm wrong, you think your child may hurt themselves, right? And that perhaps is something that's foreseeable, that perhaps your child could have suicidal ideations and maybe they're going to hurt themselves. But would you ever in a million years think, was it foreseeable to you that your daughter might go shoot up her school? I don't know. Thank you, Maureen, for your super sticker and your generosity every time we go live. Joe Huck says, this is too important a case, setting precedent as to parental responsibility for her to be found guilty on such a charge. Evidence is not strong enough. Listen, I think I agree with you. But I see the way it's going in other chats and people are like 100% guilty, 100% guilty. Absolutely. She should have stopped him. She should have gotten him help. She should have taken him to a doctor that same day. I submit to you, even if she took him to a doctor that same day, even if she was able to get a doctor's appointment for a shrink that same day, and they went to the doctor that same day and he had a session for an hour and he came home, what's to say he wouldn't have gone to school and done it the next day? I just don't think that would have fixed this, that would have prevented this. So I'm conflicted. Erica Olson, teens are very good at hiding their troubles from those close. Parents can't always believe the problems as serious as they are. I agree. Grammy B says, I agree. Just Chrissy the Crone, as a law enforcement family, we had struggled with the curiosity of our weapons, thus made excessive cautious moves always. Yeah. I know. I just, I guess I'm lucky that I never had any of my kids get into any serious trouble or any trouble with the law ever. But Ethan had never been in trouble before either. So so I'm having a hard time. It's not like the kid had been arrested 10 times on other charges and they had knowledge or for the foreseeability in that kind of case would be easier for me. In order to find, we're going back to the jury instructions now. In order to find that the death of the victims was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting someone was reasonably foreseeable. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or a failure to act. In order to find that the defendant was grossly negligent, you must find each of the following 3 things beyond a reasonable doubt. So this is the second way that they can find her guilty. The first one was breach of a legal duty, and the second one is gross negligence. All 3 things a juror must find beyond a reasonable doubt. Number 1, that the defendant knew of the danger to another. That is, she knew there was a situation that required her to take ordinary care to avoid injuring another. Number 2, that the defendant could have avoided injuring another by using ordinary care. And 3, the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. The verdict must be unanimous. What say you, my friends? What say you? I'm having a problem with this. Bice, agree. Evidence is not there, period. It doesn't matter about personal opinion, period. Glad the jury is taking their time. Yeah, I think the jury might be hung. I don't know that 12 people, if 12 people in our chat cannot agree on this, I don't know that these 12 people who have sat there, and this has not been a long trial at all, you guys. This was only 7 days of testimony, 6.5 days of testimony. Hi, Jules. Is there a difference in the sentence between the one charge over the other charge? No, because the jury just needs to find one or the other reasons for finding her guilty, and they don't even have to agree on which one they find. So they can either find failure to perform a legal duty, that could be one way to find her guilty, or gross negligence, one or the other. They all do not have to agree on which one it is, but as long as they all agree on one or the other, that leads to a guilty verdict. And the sentence is the same. I believe it's up to 15 years for each count. And there are 4 counts of involuntary manslaughter. And because this case is always, always, always about the victims, we can never, ever forget the victims. 14-year-old Hannah St. Julian, 17-year-old Madison Baldwin, 16-year-old Tate Neer, and 17-year-old Justin Schilling. As always, our thoughts and prayers are with their family, friends, everyone who is missing them, and everyone who is affected by their loss way, way, way too young and in this horrific, horrific way. And the person who pulled the trigger is a monster. He will never see the light of day. He is serving a life sentence without parole plus 24 years. Of course, that's going to be appealed. He was sentenced as an adult. That's another thing, another problem that I have. He was sentenced as an adult. And yet in this case, we want to hold the mother responsible for not controlling her child. So is he a child? Is he an adult? I mean, I feel like you can't use it as a shield and a sword. So maybe the jurors will take that into consideration. And the possibility is also sometimes they just disregard the law and just go with their feelings and say, we disagree with the law. They're not allowed to talk about that or say it publicly. It's called jury nullification. We're not going to agree with the law, but in our own moral conscience, we just cannot find her guilty. I don't know. What say you? That's why I come to you guys, because I want to know what you're thinking. Yes, Kate, so sad for the victims. Beautiful souls, all of them. Beautiful, beautiful babies. I call them babies because to me, they are babies. Absolutely never should have happened. But can we send the mother to jail for it? I just don't know. I just don't know, you guys. Jade says, I just can't get past how they didn't make 100% sure the gun was locked up. Grew up with guns in home and dad had them in a Fort Knox safe. She says it was locked up. Ethan didn't testify, so we don't know if the gun was locked. Do we know for sure whether the gun was locked up? And she's blaming it on the husband. She's blaming it on the dad, and he's going to go to trial in March. Yes, and the 7, I'm sorry, Marie, you're absolutely right. In addition to the 4 lives that were tragically lost, there are 7 others who were injured. And I'm not going to forget them. I meant to say that, but then I got sidetracked by a comment. And yes, Marie, of course, our thoughts and prayers are always also with the 7 who were injured in this horrific accident. It wasn't an accident. It was an intentional act by a psychopath. But should his mother have known that he was a psychopath? That's what I can't get to. Michelle, the school counselor and the dean suggested that he was not a harm to any other individual. These are professionals that were giving this parent advice and allowing him to stay in school. Yes, they said point blank, we didn't want to send him home because we didn't want him to be alone. Obviously, they thought he was a danger to himself. Why didn't they call 911? Why didn't they get him on a 5150 hold, as we would call it here in New York, which is an involuntary 72-hour hold when you believe that someone is going to be a danger to themselves? Why didn't they ask the parents when they were in that meeting, does he have access to a gun? You know, they're making a big to do about the fact that Jennifer CRUMBLEY never told them that he had a gun, but they never asked. They never asked if he had access to a gun. Not only that, they should assume that every kid in their school has access to guns because they have late start Wednesdays during hunting season when they start school at 10:30 so that kids can go hunting before school. So they should automatically assume. Have you heard of such a thing? I live in New York. We don't have late start Wednesdays during hunting season. And the dean testified that they have to remind students not to bring their guns to school during hunting season. So they should assume, in my opinion, they should assume every kid has an access to a gun. And they're making such a big deal that the mother and father didn't tell them that Ethan had access to a gun, but they also didn't ask. And they also didn't search his backpack. Janice says, but when she saw the picture of the gun, she should have immediately at least mentioned it. I don't know. Do you think that's enough to throw her in jail? That she didn't mention it? The school counselors said, we're not concerned by this. We don't even think it deserves discipline, these pictures. It was more the words they were concerned about. Sarah said, yeah, that's so weird. Don't know what you're starting. Yeah, ATS News, the late start Wednesday during hunting season. They start school at 10:30 so kids can go hunting before school. The last stream that I did, we played the testimony of the dean of students who was responsible for discipline. And he said that we have to remind the kids to not bring their guns to school during hunting season. And they also take pictures with their guns for homecoming. That their homecoming pictures often they pose with guns, not in school, but at home. So this is a town, this is a county where guns are prevalent in most, if not all, families. So not enough says it completely changed after the school put hands on the backpack. Yep. During the parent meeting, the dean went to get the backpack of Ethan's that was in the classroom and made a joke to the teacher who handed it to him because when he took hold of the backpack, he thought it was very heavy. And he said to the teacher, wow, you must be really strong. This is really heavy. But he said there was no reason for them to search the backpack. If him drawing a picture that day of guns and blood and, these thoughts won't stop wasn't enough for them to search the backpack, I don't know. This is what I have problems with: the intervening acts, the intervening causes, the so many ways that this could have been prevented that day. But again, in my mind, it doesn't mean that it wouldn't have happened another day, right? Sherry Davis, New York has walk-through metal detectors. Sounds like Michigan should do so. Then they don't have to make announcements or worries about children taking them to school. I made this suggestion the other day. I said, why don't they have metal detectors during hunting season? Why don't they automatically search backpacks during hunting season, just in case somebody by accident has a gun, by accident? And somebody said, who's going to pay for the metal detectors? I don't know, but this is a really rich county. According to Wikipedia, they're one of the richest counties with over 1 million, population of over 1 million in the country, or they were in 2020 when the survey was done. Ms. Smith says, I swear it feels like Melanie's downloading my thoughts in real time. I don't know. Celabella, but we know our kids, right? Some do, some don't. People have different parenting styles. Again, I submit to you. This kid was exhibiting issues and he even asked for help. The mother didn't have him on her insurance. I don't know that he asked her for help. She said he did not ask her for help, right? That was her testimony. What came in about help is that he texted his friend, I asked my parents for help and they laughed at me and told me to get over it or something. So we don't know if he was telling the truth in those text messages. And before I send a woman to jail or anyone to jail for up to 60 years, I don't know if they have consecutive or concurrent sentencing there. And for example, in Utah, I think it's a maximum of 30 years consecutive. So I don't know. This would probably be up to 60 years, I'm thinking, because of the charges. I would need to hear it. I would need proof that she actually was asked for help. But again, I'm having problems with the but for causation. Even if she did get him help, would this still have happened? Anyway, another day. I don't know. I don't know the answer. Lisa Cartwheel says, not county. I lived in Oakland County my whole life and never heard of a late start for hunting. Well, he testified to it. Go back and watch my last stream on this. Hi, Maxter. I believe the school failed him as much, if not more, than the mother. I think the words are more telling than the pictures. Yep. Yep. Forensics 805. If they only checked the backpack. I agree. The dean even said the backpack was heavy. And a lot of people were in the comments like, listen, the school is not your parent. You got to be the parent. It's not up to the school to prevent something like this. You need to, I don't know. I don't know what the answer is. I do know that there's a lot of very strong feelings on both sides of this issue. Kellen, will teachers who don't search bags and lockers start being held responsible if this case ends in guilty? Seems like others should be charged. Thanks for the live. Thanks for coming in. Tuning in for the live. They have the right to search lockers and bags. And if this didn't cry out for a search, I kind of wonder what does, you know? I don't know. What does? Like what would constitute reasonable grounds for a search? He said they would search if they had reasonable suspicion that somebody had a vape in their backpack. So kids drawing this on the paper that day, picture of the exact gun, the thoughts won't stop. I don't know. That's not reasonable suspicion. To me, it is. Hindsight's 2020, but I don't know. I think even in the moment, it would be the first thing that they should have done, or they could have done while the parents were there. Everyone looked in the backpack together. I don't know. Hi, Corporal, U.S. Marine Corps, retired, Semper Fi. Why would they mention they had a gun at home if they have had guns at home for years? It's not something that has changed or would have even been connected. And they had 2 other guns in the house before they bought him this gun. You know, and the thing about him looking for bullets during class and the mom saying, oh, just don't get caught. I'm going to submit this to you. If every kid in that school is told not to bring their guns in during hunting season, and many of them go hunting before school, would a kid looking on Amazon or wherever they would look for bullets or ammunition during school time be something that was that unusual? And when the mom said, you know, don't be stupid, don't get caught, was it kind of like, don't get caught even on your phone shopping for anything on Amazon but it bothered the teacher enough to bring it to the attention of administration. And they sent it to the mom. And they didn't think it was serious enough to search his backpack. So when you look at the totality of the circumstances, the day before, they have a teacher saying, listen, he's looking up ammunition in class. I'm a little concerned. The very next day, this happens with the drawing of the gun and the thoughts won't stop. And, you know, when you put all those things together, should they have had a little bit more concern? Would that have warranted a search? I think it would. I got a hard time getting past that, you guys. Hard time. Because there were some journal entries that I don't think we heard in this trial that were in the Miller trial, where he said, I want to get caught. Maybe sometimes I want to get caught, like messages that he sent to his friend. And if he had been caught that day and the police came and he was arrested, maybe put in a psychiatric hold, maybe we wouldn't be here today. Snazzy Trinkets Jewelry, thanks for your super chat. Double-edged sword. School has rights to search kids' lockers and backpacks, but have immunity when they don't. Yeah. Is that fair? I'm going to submit to you something maybe a little crazy, but I'm going to submit to you that a school has a legal duty to keep their students safe, from not only intruders that may breach the entry to the school, but from other students. They also have a duty. And, which duty do you think has more culpability here? Donna says, some kid from the school told me they have bullets in their backpacks. It was a normal thing in Michigan. Stephanie, how many times have we heard teen killers told their friends what they were going to do and the friends don't say anything? They can't imagine it's the truth, right? And he did tell his friend a lot. A lot. Vice. Attorney comment on another channel said the jury didn't bargain to hear a case with such national legal ramifications. They sure didn't. They sure didn't. And that's why I don't think they're coming back. They've been out for 346 minutes. I don't think they're coming back today. I don't think they may even come back tomorrow. Kellen says Snazzy made a great point, so let's go look. They spend more time with the students, meaning teachers, and the parents have to send them by law in most states. So why is JC on trial and not school employees? All right. Sandy Beach, calling it out. Why would a parent support Ouija boards, violent games, guns, violent drawings, downplay bowls flying across the room, requests to get him help, and his own requests for help? I played with Ouija boards as a kid, but I never had any desire to go shoot up a school. So I don't think that allowing your kid to play with a Ouija board is any different than, you guys tell me if you think I'm wrong, but I don't think that's any different than, playing Cards Against Humanity or some other board game. I don't know. To me, that's okay. Violent games, he's playing video games. A lot of kids do. My kids aren't really into it, but I think it's pretty common. Guns, again, they're in gun country where kids go hunting before school. Violent drawings. The violent drawings, I think, just came to their attention that day, right? I don't know that they had any prior knowledge of any prior violent drawings, that there was any history of that. In fact, and now I can't remember if I'm confusing the Miller hearing with what I heard in this trial, so that's why I probably shouldn't have watched the Miller hearing, but the school had more knowledge of other things that Ethan had done, and they did not notify the parents. Some other things that he wrote that were scary that they never told the parents about. So they actually may have had more information on Ethan's propensities, let's say, than the parents did. Downplay bowls flying across the room. I think she said that he liked to pretend that the house was haunted because it was built in the 1920s, and that was sort of like a running joke. Requests to get him help. Again, I think he texted that to his friend. I don't know that he ever said to his mom directly, get me help. So I don't know, Sandy. I know where you're coming from because I know a lot of people feel the same way. But I feel like those things were explained. So let's take a look instead of going to closings right now. I kind of want to go to the thing that I was talking about, Jesse Weber, because there's a bunch of just pieces of her testimony that are going to answer a lot of the comments and questions that we just heard. So let's go to that one first. All right, shall we? Oh, thank you, Sarah, for clarifying. That was in this trial. Also, why would they not have been able to show that from the Miller hearing, the psychiatrist stated he hasn't been diagnosed with a mental illness? There's a lot that this jury didn't hear. And those of us who did watch any portion of that Miller hearing, have a lot more information than this trial, so I probably shouldn't have watched it, but that's why I did it after the close of evidence, because I didn't want to be confused, and it didn't really help me because I am a little bit confused. So let's take a look at our friend Jesse Weber and some of the things that he calls 9 disturbing moments from Jennifer CRUMBLEY's testimony.
Oh, absolutely.
Just let me know that the volume's okay. Usually Law and Crime's volume is pretty good, so I think we're
You
gonna
could change what happened, would you?
Oh, absolutely. I wish he would have killed us instead.
Extramarital affairs, parents may be on the run from police, and a parent cries for help from a teen who would soon become a school shooter. It is all being revealed in the Michigan trial of Jennifer CRUMBLEY, the mother of the convicted killer. But now we have Jennifer CRUMBLEY, the defendant herself, on the stand, and there is a lot to break down. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. I've said this before, I'm going to say it again. I cannot emphasize enough how important this trial happening in Michigan is right now for Jennifer CRUMBLEY. Why do I say that? I say that because CRUMBLEY is the first parent in American history to be criminally charged for a mass shooting that their child committed. Her husband, he goes to trial next month, but we're talking about Jennifer CRUMBLEY right now. Jennifer CRUMBLEY, her husband James, they are being tried separately on charges of involuntary manslaughter, and their son opened fire inside of Oxford High School in Michigan in 2021, killing 4 students. Now, the shooter himself entered a guilty plea, serving a life sentence. The prosecution contends that the CRUMBLEYs not only bought their 15-year-old son a handgun, but also ignored signs that he needed mental health treatment. The idea here is that they were negligent, that the negligence was a cause for this shooting, that it was reasonably foreseeable.
Okay, but again, negligence is a standard for a civil case. That's why I'm having a really big problem with this, because this has to be a lot more than negligence. I mean, this has to be a complete and total disregard for human life. They need to have known that if this kid had a gun, he would have shot up the school. And I'm not seeing enough to convince me of that. I don't think negligence is the proper standard here, because in that case, we could all be negligent. We could be negligent for letting our kids watch too much TV, or for playing with the Ouija board, or for playing video games that are violent. And somebody said go back and read Tiff's question. So here we are, Tiff. Take this particular weapon out of the question. Say he used a machete to attack. Would the parents still be liable? I mean, under this theory, if they bought him the machete, yes. I think so. I don't know, but you're right. I mean, that's a great point. KPEC says, everyone keeps saying he cried for help. He never texted his parents saying he wants help, and they never seen his journal beforehand. I know, KPEC, and that's why I think a lot of this evidence that came in was highly prejudicial, because the jury might be confused. Look, I'm an attorney with 30 years experience, and those jury instructions confuse me.
That this could happen, and that they failed to act, disregarding the warning signs, disregarding the risks. So she faces 4 counts of involuntary manslaughter, with our understanding being that each one carries up to 15 years in prison. Now, over the past week or so, the state has presented pages and pages of text messages, social media messages, photos, journal entries, and more. They've called multiple witnesses to the stand. Those witnesses included professionals like detectives and digital forensics experts, school officials, as well as victims who survived the shooting. Prosecution once again played video from inside the school showing what happened during that shooting. CRUMBLEY, when this was going on, she kept her head down and cried. Now, school officials, they testified about how the shooter.
Hey, Jennifer Bossert, the standard is beyond negligent, but based on what Jesse Weber just said, he's calling it negligence. And we're going to go back after this and read the jury instructions again. And although it says gross negligence, there's a lot of references in there to ordinary care. And I find it hard to reconcile the two. I'm not agreeing with these jury instructions. I think they're going to have a difficult time deciphering them.
Acted in school, and concerns that were raised about his mental health. The shooter was caught looking up bullets while at school, and also wrote in an autobiography poem that his family was a mistake. The parents were also called to the school when their son drew a gun on a test paper. Officials testified that despite being encouraged to get their son to see a counselor as soon as possible, Crumbleys allowed their son to stay in school that day, said that they needed to return to work. And not long after, only a few hours later, he would open fire. So they really stacked up the evidence against Jennifer Crumbleigh. And there was a lot of it. There was a lot of it that, honestly, in my opinion, I think the opinion of a lot of people who are watching this who will say it looks really bad. For example, Detective Timothy Willis with the Oakland County Sheriff's Office testified about all of these notes found in the shooter's journals.
In reading the journal, were there passages in there indicative of requests for mental health help?
Yes.
Can you read what's been identified here as page 6 of that journal?
Yes. The shooter writes, I have zero help.
Okay, this was in his journal that his mother never saw. Stuff is highly prejudicial. And just because it was in his journal doesn't mean that he told this to his mother. I have zero help from my mental problems, and it's causing me to shoot up the school.
For my mental problems, and it's causing me to shoot up the school.
We'll move on to page 5. Can you read this passage, please?
In this one, the shooter writes, I want help, but my parents don't listen to me, and I can't get any help.
Okay, so just because he writes in his journal, I want help, but my parents don't listen to me, so I can't get any help. When this is offered to prove the truth of the matter asserted, as it is here, this is hearsay. So I have a problem with this being admitted into evidence because it's being asserted, it's being offered for the truth of this, that he told his parents they don't listen to him. He couldn't get any help because he wanted help, but his parents wouldn't listen to him. I don't know. I don't have any evidence that Jennifer Crumbleigh is going to say, yes, he asked me for help and I didn't listen to him, so he couldn't get help. That's where I have a problem with this journal coming in, but I wasn't the judge in this case. Thank you, Retired Irish. Dennis says, legally, you have to be 21 years old to own a handgun. The gun was registered to his dad. His dad bought it. It was registered in his dad's name, but the law in Michigan is that you can go to a range and shoot a gun at 15. I guess you just can't own a gun. But again, it was registered to his dad. So there's that.
Well, this is page 19. Can you read that?
Yes. Shooter writes, my parents won't listen to me about help or therapist.
Sir, in that journal, were there entries about the shooter's desire to obtain a 9mm handgun?
Yes.
This is also
Again, I'm going to say this again. I'm going to keep saying it. Just because it was written in the journal doesn't make it true that he really told his parents that.
Exhibit 401, page 22. Could you read those quotes, please?
Yes. The shooter writes, I want to shoot up the school so badly. Soon, I'm going to buy a 9mm pistol.
Sir, were there any passages regarding the shooter's plan for the actual shooting?
Yes, there were.
Okay. Here's page 3, also exhibit 401. Could you read that, please?
Yes. Shooter writes, I'm about to shoot up the school and spend the rest of my life in prison.
Were there any journal entries about the shooter's access to the 9mm handgun?
There were.
This is also exhibit 401, also page 3. Could you read that, please?
Yes, sir. The shooter writes, first off, I got my gun. It's a SP 2022 Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this now. So yeah, I'm going to prison for life, and many people have about 1 day left to live.
Do you have any evidence to believe that Mr. Crumbleigh or Mrs. Crumbleigh saw the journal?
No, if I had evidence of that, I imagine the charges would be different.
If you had evidence
If I had evidence of that they saw the journal, the charges would be different.
saw the journal,
Meaning they wouldn't be involuntary manslaughter, they would be murder. Slippery slope, my friends.
charges would be different?
Yeah, murder, I would
Okay,
imagine.
okay. So the journal was located in the backpack that belonged to the shooter,
Yes,
correct?
correct.
There were also a number of other papers in that backpack.
The journals were in the backpack. They were in the backpack. So if they searched the backpack and they found the gun that day, or if they just called the police to take him out of there, they would have found the gun, they would have found the journal, they would have known what he was up to, and they could have thwarted this whole thing that day.
That you described,
Yes,
you don't have any evidence that Mrs. Crumbly ever saw any of those papers, correct?
correct.
So it seems that the teen was really struggling and wasn't getting the support that he needed from his parents. But the defense is trying to reframe things. They're saying, no, the Crumbleys were the ones who were truly in dark about what was going on until after the shooting. That's when they found out. By the way, one of my favorite things about being a host on Law and Crime is how passionate our audience is. You guys don't just sit back and watch. You engage, you leave comments, you give us feedback, you
Okay, now he's going to do a little commercial. So we're just going to go by this a little bit.
Ms. Crumbly blasted the school for not forcing her son to go home or searching his backpack. School officials testified that they didn't want him to go home if he was going to be alone and that there was no reason at the time to search his backpack. They said there was no reasonable suspicion. Now, that's important because the defense is saying if the school wasn't worried about him, if the school didn't feel threatened by him enough to force the parents to take him home, how can you hold the Crumbleys responsible? How can you say that they should have known? It's a bit of the blame game. Though I will tell you, the prosecution has argued through the testimony of school officials that if the school had known the shooter had access to a gun, like if they had known that his parents had bought him that firearm, then they would have treated this much differently. Because Jennifer and James Crumbly didn't make that known. They didn't tell the school about the gun. So in other words, it's their fault that their son wasn't forced to leave school. Now, Jennifer Crumbly counters that. She says, no, school, they didn't give us the full picture. They didn't tell us everything that was going on. Ethan was writing things you didn't tell us. We didn't understand how much he was struggling. But we also heard testimony this week about the Crumbleys on the run before they were arrested. And I say on the run in quotations because there was also testimony about cash withdrawals made by the Crumbleys. They were apparently camped out at an art studio in nearby Detroit. A man who had business in the same building recognized the car as one that police were looking for. They called 911. So the Crumbleys were asleep on a mattress on the floor when the task force members burst in. But Jennifer Crumbly, or at least her defense is contending, they were just trying to escape all the media attention surrounding them and that they had every intention to turn themselves in. So they really weren't on the run. By the way, my opinion, I don't really think that that piece is the most significant in this case. Why do I say that? I say that because if this were a murder case and we didn't know who did it, and then you have a suspect fleeing, that's suspicious. That shows consciousness of guilt. Here,
Yeah, I agree with them. I agree with him on this.
even if we accept that they were hiding, does that really affect the legal analysis of whether they were guilty of failing to prevent the shooting from happening? Sure, it looks bad, but they could still be innocent and flee because they're scared. I don't know. That's my take, at least. Well, the prosecution officially rested its case on Thursday. Now, you could argue that things don't look great for Jennifer Crumbly at this point, right? I mean, on top of everything else, there are all these text messages I haven't even mentioned, like from Jennifer to her son. After he opened fire on the school, she wrote, "Ethan, don't do it." You could argue that shows she knew what he was capable of. When he got caught looking up ammunition in the school, Jennifer texted him, "LOL, I'm not mad at you. You have to learn not to get caught." So to combat what the prosecution had
Not to get caught looking at your phone in class, not to get caught internet shopping in class, or specifically not to get caught looking for bullets in class. Like I said earlier, if you're new here, I said earlier, this school had reason to believe that every one of these kids or the majority of these children in this school, these students had guns at home because they had late start Wednesdays. During hunting season, school didn't start until 10:30 and they would have to remind these students not to bring their guns to school during hunting season. So they had every reason to believe that most of these students had access to guns or had guns in the home or were hunters.
Had presented so far, defense attorney Shannon Smith called her client to the stand as the first witness for the defense. Remember, this is the defendant's decision to take the stand. Her decision. In my opinion, she had to do it. I don't say that lightly. There's a ton of risk associated with the defendant taking the stand.
Sometimes it happens. I swipe myself out, but we didn't miss a beat because I caught the video. We're right where we need to be. Scott says victims' parents can probably win a civil case for gross negligence with these charges, but these charges aren't enough in a criminal case for 4 counts of manslaughter, in my opinion. That's why I think the jury's not coming back anytime soon. I think there's going to be some pretty heated discussions in that jury room. We learned the makeup of the jury pretty evenly split between men and women, although 5 alternates were chosen this morning and they are not deliberating. So there are 12 left. I don't know of the 12 that are left, how many are men, how many are women, but they are mostly all parents and nobody is anti-gun. And I think most of them do own guns. Jules 1999, when you sit back and really think about all this means to all parents, size, it's not good at all. Hope the jury comes back with not guilty. I did it again. I said I need to have a meeting with StreamYard so that it's impossible to swipe myself out by just touching my keyboard over here or this mouse pad. Hunting season. That's nuts. Yeah. Listen, I have a lot of international viewers, and those of you from down under and from across the pond have way, way stricter gun laws than we do. You guys are like, what? What is going on here? We have such strict gun laws in our countries that we don't even this doesn't even happen. It's not even a thing. Let's go back to the video.
Get caught. So to combat what the prosecution had presented so far, defense attorney Shannon Smith called her client to the stand as the first witness for the defense. Remember, this is the defendant's decision to take the stand. Her decision. In my opinion, she had to do it. I don't say that lightly. There's a ton of risk associated with the defendant taking the stand. How will they come off? Will they get tripped up in cross-examination? I think taking the stand is vital in self-defense cases when you have to explain why you used lethal force. But here, I think it was also necessary. It was necessary for her to explain why she wrote the things that she did, why she acted in a certain way. Why did she do more? So let's break down her direct examination.
Hi,
Start by saying your name.
it's Jennifer Crumbleey.
And Mrs. Crumbleigh, you and I.
This is a great point all about crime. If he was looking up bullets, then the school should have asked if there was a gun in the house. How about, I'm going to take that one step further. If he was looking at bullets, the school should have assumed that there was a gun in the house. What say you?
I've been working together since December of 2021, correct?
Correct.
And is it fair to say over these last 26 months, we've discussed whether or not you intended to testify a number of times?
We have.
Do you want to testify in your case?
Yes.
Do you understand that if you did not testify, this judge, this court would give the jury instructions that it cannot be held against you?
Yes.
Do you understand that after I question you, the prosecution is going to be able to cross-examine you?
Yes.
And do you understand they're going to be able to cross-examine you about all of the evidence that's been admitted in the case, including all of your text messages or your Facebook messages to your husband, all of those messages with Mr. Maloche, all the evidence in the case,
Yes,
correct?
I do.
They get full reign on cross-examination. We've gone over that, is that correct?
Correct.
And do you have any questions for myself or for Judge Matthews about testifying?
No, I don't.
Are you doing this because anyone has threatened you or coerced you into testifying?
No.
Is this your choice?
Yes.
Is it voluntary, freely made by you?
Yes.
Is there anything you think the court should know about this decision?
No.
Does-
Do you have any questions for me, Mrs. Crumbly?
I do not.
So Crumbly started out by talking about her life. She worked in marketing for a real estate firm. She and James had been together for 18 years. They had this one son who she felt she was close to. This is all a way to reframe the narrative of a neglected mother, that this is all a way to humanize herself and her relationship with her son, show that this wasn't a dysfunctional family, but a normal, positive experience. And she also explained her personality, like the time she seemed to be cold as to what was happening, or, maybe she was talking so much about herself or focusing so much on herself. She explained that she's goes into this kind of
Hi, Lisa. I want to stop for a second for this comment. I don't think she's a monster, but is she a bad mom? Neglect is what I see. And thank you for that, because some of the cases that we cover together involve severe examples, horrific, bone-chilling examples of CA. You look at the things that happened to the Frankie children who were shackled with duct tape, the torture that was inflicted upon those children, how they were forced to run outside at 8 and 9 years old barefoot, carrying rocks, horrific things. We see so many cases where children are severely, severely physically and mentally abused by parents and other people. So, and those people, Ruby Frankie, Jody Hildebrandt, and others, Jacqueline and Trezelle West, deserve to be in jail and never see the light of day again. But when we start throwing parents in jail for having hobbies, for spending money on their hobbies, for having affairs, which, by the way, both parents were, not just Jennifer, for looking for hookups on Adult Friend Finder, for being negligent and maybe not as attentive as most of us would be, and putting them in jail for that, that's a slippery slope. And people are saying the gun wasn't locked up. I don't know that there is evidence of that, because the only person who can really say whether the gun was locked up is Ethan, and he's not here. And I think he even knew the combination. He didn't testify, and Jennifer said it was locked up, and she said it was the husband's responsibility to keep the guns locked up, and that they were locked up. So can you say beyond a reasonable doubt? Would you be able to find beyond a reasonable doubt that those guns were locked up? And even if they were locked up, could he have figured out the combination? Could he have gotten a gun another way? I just think, wait, okay, so I know the combination was 000, according to some of the law enforcement officers that testified, but did she testify it was 000? I don't know. I don't recall, but let's keep playing this and we'll see if it comes up.
analytical planning mode when something bad happens. So here's a sample of her giving some background.
How often would you and James talk about or talk to Ethan?
Well, talk to him every day. Talk about him probably every day too.
Right? What did Ethan have scheduling things you had to work out?
Yeah, he had bowling practices throughout the week, bowling matches, and he worked part-time at a diner. So we had to work out transportation and scheduling with that.
In terms of your relationship with your son, how did you think your relationship was?
I thought we were pretty close. We would talk. We did a lot of things together. I trusted him, and I felt like I had an open door and he can come to me about anything. I felt as a family, the three of us were really close.
Okay, you're getting
I
a
know.
lot of, no, it's okay. You're getting a lot of redness here. Is that normal?
Yes, because I'm talking in front of people and my nerves act up. So I get splotchy and I might break out in hives and I apologize.
Okay, but you are okay.
Yeah, I'm fine.
Okay.
Okay, Island Girl, that's a good point. Are you saying that's not this, that it doesn't matter whether the gun was locked up, that the more important thing is that they ignored that note that they were called into school about? And that's the reason that you would find her guilty? That's a fair point. What say you, my friends? What say you?
So with regard to your son, did you ever go through his text messages, go through his bedroom? What kind of a parent were you in terms of going through those things?
I did not go through his text messages. I didn't have a reason to. His bedroom, I would go through when I clean it. I come across things, I look through it to see if it was something I needed to keep or throw away. But I never went through his text messages.
So she was there for him, checking on his grades, tracked his location using an app. She knew what was going on with him. Then again, he opened fire on a school. So how well did she really know him? Hey, so quick sidebar from sidebar for a second. Look, it is a privilege to be able to tell you these stories and to break them down.
Now he's going to go into another commercial, but that was a good comment that we had there. It's a jury that is deliberating now is 10 women and 2 men. 10 women and 2 men. And I find, well, my audience, the men are coming in now. It used to be when I first started this channel, I had about 90% women and 10% men. But with some of the cases I've been covering, like Karen Reed, and this one, there's a lot more male involvement. So now we're up to like 22% men. And if you are male and you have not yet hit the subscribe button, please hit the subscribe button because it helps the algorithm. Everyone who's not subscribed should subscribe because we have a lot of fun here. And we like to talk about the tough topics, and we're not afraid to talk about the tough topics. And this is a tough topic. This is a tough topic for me because I have so many kids that I find this a little bit scary. And the Maya case was something else that I found scary too. I'm just going to take this off for a second because in the Maya case, the Kowalski versus Johns Hopkins All Children's Hospital case, we talked a lot about how scary it was to know that you could lose your parental rights by taking your child to a children's hospital and having one of their professionals wrongfully and erroneously accuse you of something like Munchausen by proxy. And you could lose your parental rights within a week and have your child made a ward of the state, which in the Maya Kowalski case, Maya Kowalski was a ward of the state, confined to the hospital for 90 days. Her mother was not allowed to visit her. That case eventually that was a civil case, but it eventually resulted in the mom, Beata Kowalski, taking her own life because she thought that was the only way for her daughter to be released from state custody. And ironically enough, it's too much to get into now, but ironically enough, she was released from state custody within a week after her mother took her own life. So it's disturbing to know that your parental rights, or to find out that your parental rights can be taken away based upon a false accusation of Munchausen by proxy by a doctor. And it could be also as upsetting or disturbing to find out that if you are not as diligent of a parent as a jury of 12 people wants you to be, that you could go to jail for 60 years in this case. That's the problem I'm having. And everyone who's saying, she didn't lock up the gun, she didn't lock up the gun, she didn't lock up the gun, she needs to go to jail, she needs to go to jail. What if it was you and you were married and you were working 2 jobs and your husband wasn't working and you were responsible for the financial well-being of the family and your husband was in charge of the guns and this horrific thing happened that I don't really think anybody would say is foreseeable? I'm also having a problem with foreseeability. You would be at fault? You'd be okay with going to jail for 60 years? I don't know. I don't know. This is a hard one. I don't think the jury's going to come back today. Let's go back to the video.
Because if you knew your son had mental health issues and you ignored that and you bought him a gun, that shows you created danger. You could have prevented the shooting from happening. You should have seen this coming. But Crumbleigh suggested she never believed her son had these severe mental health issues. And she outright denies him ever telling her that he had these problems and wanted to see a doctor or anything like that. She also explained that if anything, she always thought he was messing around, that he was sarcastic. For instance, listen to this idea about him thinking the house was haunted, because she said that was just a long-running joke.
This is a text where the prosecution admitted to show that your son texted you, okay, the house is now haunted. What time was that text at?
It says 6:03 p.m.
Okay.
I don't know if it says -4. I don't know what that means.
Okay, and then the next text, some weird just happens and now I'm scared. Next one, I got some videos and a picture of the demon is throwing bowls. I'm not joking, it's the kitchen. I'm just gonna be an outsider for a while.
I mean, I'm sure I saw them, but they just didn't stick out to me until this case,
Why didn't they stick out to you?
because it wasn't anything that was anything serious. It was Ethan just messing around.
You gotta explain to the jury, how did Ethan mess around?
So he's been convinced our house has been haunted since 2015. It was built in 1920. Around that time frame, him and his friend would go down to the basement and play a Ouija board. So they thought we had a house ghost.
Do you think it's bad parenting to allow your kid to have a Ouija board? I'm curious about this now because somebody brought that up earlier. Maybe I'll do a poll on that.
So it was around that time when he would mess with us, that things were going on in the house. Silverware was flying across the room. Doors were slamming. He actually took a video of the door and showed me when I got home. And you can clearly see where he's standing back with his phone, looking at the door that's open. You can see him walk up the door and you can kind of see him slam it, of him trying to say, see, our house is haunted. So it was that kind of stuff that he did.
What is happening again is they are taking some of these bad facts and circumstances and providing a new context to them. That's what the defense is doing. Now, attorney Shannon Smith also asked Crumbleigh about the purchase of a gun for her son on Black Friday, just days before he would use that gun to kill fellow students at his high school. Well, previous witnesses have already confirmed that Jennifer Crumbleigh was not present when that gun was purchased.
Yeah, I texted my husband and asked where you're at, and I believe he called me and told me that him and Ethan were at the Acme firearm store looking at guns,
Okay,
and then they came home from there.
okay, did they purchase the gun that day?
They did.
Okay, the prosecution brought in exhibits showing the receipts, all that. You weren't with them when they bought the gun,
No, I
correct?
was not.
Okay. You did post on Facebook a photo of the gun. We saw the post, correct?
Correct.
And in the post that's been admitted already, you described it as your son's Christmas gift. Can you explain who wanted the gun? How, what does it mean?
They had rented a 9mm at the shooting range before, so they knew it was the type of gun or the size gun, I guess what it is, that they wanted to get. And my son and my husband did a lot of texting back and forth. My son did a lot of research on it, and they're comparing different ones that they wanted to buy. That went on for a couple months. My husband just kind of kept blowing it off, like, not right now. And then I guess when I was out shopping, they said, well, let's go try on Black Friday, see if we can get one on sale or if there's any deals going on.
Okay, so they ultimately did get one.
Right.
Now, did you object? Did you say, I don't want that gun in the house? Anything like that?
No, I was more angry that they cut into our Christmas tree time. Usually cut my Christmas tree down right after I get back from shopping, but I had to wait for them. So I was irritated.
I mean, I'll say she doesn't make the best witness. She doesn't seem, she seems a little selfish. She seems a little cold. She seems a little, she's not the warmest person in the world. I think I would have prepped her differently if she was my client. But doesn't make her a criminal.
At that.
You know, you may not like her, but doesn't make her a criminal.
Crumbly testified the gun was kept locked away and that the firearm was her husband James's responsibility, a common theme of pointing the finger at him, not her.
Did he have free access to that gun?
No, it was for him to use at the shooting range only,
Was he allowed to take it out?
not without my husband around.
Did he know where it was kept?
My husband hid it usually in our bedroom in different spots.
Okay, what was the intention of hiding it?
That's just what you're supposed to do.
Okay, and when it was hidden, was it locked in any way?
It had the cable lock on it.
Okay, and you again testified about the key being in a beer stein.
Correct.
Would the beer stein be right by the cable lock? or-
No,
Okay, so where would the beer stein be?
it would probably be in one of the ones in the kitchen.
And when Smith questioned her client about the seemingly
Okay, so her testimony is that the gun was locked. That's her testimony. What evidence is there that the gun was not locked? There's evidence of what law enforcement saw when they went to search the home after this event. But do we have any evidence in this trial, forget about the Miller hearing, that this gun was left unlocked? What say you?
damning evidence of premeditation that the school officials found, Crumbly said she simply didn't know about any of that.
Okay, Exhibit 166. This is from September 8th, 2021. It starts off with an email from Miss McConnell to Sean Hopkins. It says, can you please touch base with Ethan Crumbly? In his autobiography poem, he said he feels terrible and that his family is a mistake. Unusual responses for sure. He writes back, thanks for the heads up. I'm in senior meetings throughout the day. I'll try to catch up with him. Were you aware this was ever a discussion or an issue?
No,
Were you aware that Mr. Hopkins ever talked to or tried to talk to your son?
no.
Did anyone ever call you to make you?
Okay, so that is part of the things, one of the things that the school knew that they did not make Ethan's parents aware of. And this is an email from the counselor, from a teacher to the counselor, Sean Hopkins, who did testify during the trial. And it's dated September 6th of 2021, before, obviously, this incident. More than 2 months before.
Or tried to talk to your son?
No,
Did anyone ever call you to make you aware of any of this?
no.
If you heard this, how would you react, or what would your reaction be?
I'd be definitely concerned why he feels like his family's a mistake and he feels terrible. So that would be a concern to me.
Okay, so this is something you were unaware of.
Correct.
And in fact, when did you find out these emails existed?
We started getting discovered.
Okay, so in this case.
Correct.
Crumbly says that in the days leading up to the shooting, her son seemed to maybe be a little distant, maybe a little sad, but nothing that raised any kind of red flags for her.
Do these texts look familiar to you?
They do.
Okay, who are these between?
These are between me and his friend's mom.
Okay, and you start off with Ethan my son is in bowling tonight. I just want to let you know, not sure if he needs a partner. Why are you texting that?
I don't know why he wasn't bowling tonight, top of my head. But they have partners on certain nights of the week, and so him and his friend were always partners. So I was letting her know that he wasn't going to be there.
Okay, this is on one date, April 29th. Did you talk to her on other dates, or is this like the only time you talked to her?
We've talked back and forth quite a bit.
Okay, Now, on this date, you say he's been acting kind of depressed. I don't know what's going on. I'm not sure if there's something bothering him at school, but he doesn't really feel good. I can't get anything out of him. Friend's mom mentions he stayed home from school today too. The only time they're happy is when they're together. Talking about grades, you had mentioned this is all new.
So these text messages are between Jennifer and Ethan's friend's mom, and they were in April of 2021, so 7 months before the shooting. And she's talking about she thinks he's depressed.
To me, I'm not used to my son being moody. He's usually pretty happy and will talk about anything. I do know he's been stressed about school and his grades. We called the school, but she wasn't in social do it tomorrow. I think his grades have a lot to do with it. I just got to a point where he's got so far behind and we were out of town. He's having difficulties making it up. Where were you guys out of town?
In Florida, my mother-in-law had passed away, so we were gone for a couple of weeks in the middle of April, taking care of funeral arrangements and everything.
And at this time, when you describe your son as being moody or depressed, did you think it was anything that warranted getting medical attention?
No, he was just being quieter. He's a quiet kid. He was just being quieter than normal. And I'd ask him if everything okay. He'd say fine, but I could just tell he was a little sad. And I thought maybe I didn't see his friend in a couple of weeks. So I don't know if maybe they got into a fight and they weren't talking.
And then all of this led up to the day of the shooting, November 30th, 2021. Remember, both parents went to the school when a counselor raised concerns about a drawing of a gun.
Mr. Hopkins testified that he sent you something. What did he send you?
He sent me a copy of a math worksheet that had the scribbled out drawings on it.
Okay, and I want to ask you, the night before that scribbles out drawing thing came to you, did you have any interactions with your son?
Yes, we did.
What were those about?
I saw in Power School that he had an E in geometry. So we got in an argument again about his grades. We took his phone away and told him that he couldn't go to the shooting range until his grades were brought back up.
Okay, so you guys had this argument the night before. We saw lots of messages where you thought everything was fine that Tuesday morning. Is that how you felt?
Yeah.
Okay, so when you got that math paper texted to you, do you recall saying anything to Ethan on the phone, on speaker?
Yeah, I asked him why he did that.
Okay, what were you thinking at that point?
I was actually kind of angry because I thought he did that in like defiance of us yelling him about missing assignments, and here he is drawing pictures on an empty assignment page in geometry.
So you felt like it was specifically him sending you a message about the night before.
Yeah.
How did that meeting go?
It was pretty nonchalant. It was pretty brief. He started to tell, he basically filled me in on what my son and him were talking about for the last hour and a half. He said that my son told him that he was feeling sad over the death of our dog that we had. My mother-in-law lost his friend. So we talked a little bit about that. We confirmed it. We decided we agreed it was hard on him. He told us that he didn't feel my son was a risk, and actually gave him the option if he wanted to stay at school or go home. My son wanted to stay at school. So we all discussed that.
Did you feel like you were taking the position of, I am leaving him at school whether he can be here or not?
No, absolutely not.
Okay. Were you surprised or were you not surprised? Did you have any feelings about whether or not he could stay at school?
I didn't really, I thought the advice that they were giving us was a good advice. We talked about him being sad, and then he said being around peers usually helps. We all agreed to that. My son gets very stressed out when he does virtual school. So we agreed that it might stress him out more to do his school remotely the rest of the day. But there was never a time where I would refuse to take him home. I could easily, if he wanted to go, take him with me. I had no issues with that.
So again, the school didn't make a big deal of it. Better for him to be around peers, deal with this later. If the school didn't think it necessary to take him out and they didn't force him to leave, should Jennifer Crumbly be held responsible? They didn't search his book bag after all when that was the book bag that had the gun. A fair question, right? Reversing the narrative that she didn't take him home purely because she had work obligations, that it was more of a joint decision. Which, by the way, there was testimony to suggest that her boss would have let her focus on her son more, not work. Okay, so that helps the prosecution. But anyway, if the school knew that the shooter had a gun at home, that would have changed things. That's according to them. That's according to the school officials. So that's a point that's going to be difficult for the defense to contend with, that they never told the school about the gun. Well, as we know, within just a few hours of his parents leaving, this 15-year-old, he started shooting, killing 4 people, injuring 7 others. And Smith asked Crumbly about how she had heard about the shooting and the slow realization that her son was the shooter.
You sent a text to your son that says, "You can talk to us." Why did you send him that?
After I left the meeting, I knew that he was sad about things, and I just wanted to let him know that he can talk to us about anything. Just wanted to make sure I opened that door. Just let him know that we're there for him and we love him.
Okay, and he said he loved you. Do you recall that?
I do.
Okay, was there anything unusual about that?
Yeah, he's at that age where it was hard to get "I love yous" back out of him. For me to open my text and just see him randomly saying "I love you" was abnormal for him.
Okay, did you think anything at that point?
No, not right at that point. I think I said text back "I love you too." I don't remember. I believe I did. Yeah.
Okay, and later in the thread, you say, "Don't do it." So when you hear there's an open shooter at the school, I want to know, in your mind, what do you believe is happening?
Well, my husband had called me when I was still at work, and he said there's an active shooter at Oxford High School. I can't get a hold of Ethan. And that's when I opened my phone and I saw the "I love you" text. And then I texted him, "Are you okay?" In the process of it, I was getting my stuff and running out the door, letting my boss know that I had to go to my son's school. It was on 75 when I was trying to get to the exit, that my husband called me and he asked me where I hid the bullets, and I told him, and then he said the gun was missing. So instantly I'm like, oh my gosh, he's got the gun. I didn't actually think he was at the school shooting it. I thought maybe he walked home and got the gun and was in the field by the school. I didn't imagine my son actually going into a school and shooting. And then when we got more updates, I was like, oh my gosh, he's a school shooter. He's going to kill himself, because in my mind, that's what school shooters have done. They've killed themselves after. So I yelled in my talk to text, "Ethan, don't do it," because I thought he was going to kill himself.
And at the end of her testimony on Thursday, Crumbly was emotional.
In some of the messages the prosecution admitted, you say that you failed as a parent. Are you a failure as a parent?
I don't think I'm a failure as a parent, but at that time, I guess I felt bad that Ethan was sad at those things. And I guess I don't know. I just felt like I failed somewhere. I don't really know how to describe it. It's just that point in time, I just kind of felt like somewhere I failed.
Do you believe there was anything,
Let's see a show of hands. How many parents in the chat have ever felt like a failure as a parent? Anybody ever feel like a failure as a parent? Does it mean that you think your kid is going to go shoot up a school? Any parent who says they have never felt like being a failure as a parent is not telling the truth, I submit to you. The verdict is in? Yeah? Oh, well, I think we're going to have to go to that. Whose coverage do you want to watch for that? Seriously? I can't even believe that that's true. All right. Are you sure? That was my problem again. Oh, are they, you think they're just going to be dismissed for the day? All right, you know what? Let's keep chatting. I'll put it on over here and we'll watch it and we'll see. If they have a verdict, you tell me. Oh, it's a jury question? No verdict. All right, we can keep going where we were then, I guess, eh? Law and Crime, that's what I was thinking, has the best verdict. I think she's going to let 2 of the 5 jurors go. That's what I'm hearing. You're done for the day? I do not think there is a verdict right now. Yep, I see Sally, they're heading home, but they're just sending the alternates home. Woot woot. You can watch me and someone else at the same time if you have the, 2 different devices. Scott says the verdict is in. I don't think so. I mean, I've got another stream on right here. I mean, it looks like it's 4:38. There's no verdict. I think they're gonna send these jurors home. Put it on for you. We'll watch it together. There's no sound right now, so it's not us, it's them. And their audio is not great. Thanks for watching.
I know you guys have all had an exciting day. We've completed puzzles, done Sudoku. I heard one of you was sleeping on the floor. I won't name names or offend any of you. I'm so sorry. Hopefully you realize the reason behind it.
Okay. Anybody remember the low talker from Seinfeld?
12
This
of you
judge is the low talker.
have not come to a verdict yet, so they're going to be returning tomorrow. But life happens, and in the event that one of those jurors was indisposed, we would need one of you to fill in for them, and they would be instructed.
Yeah, this is terrible.
Deliberations all the way over again. So that's the reason for it. That being said, I'm going to dismiss 3 of you by blind draw today. Actually, I shouldn't use the word.
She's going to dismiss 3 of them. Oh, there we go.
The 3 of you not return tomorrow, but you're still sequestered. You understand what I'm saying? So some of these people sitting out here would love to talk to you, but they are not allowed to talk to you and you're not allowed to talk to them. And it's the same as every day when you leave here, you're still sequestered. I just think that you would prefer to be doing your laundry or going to work or doing whatever it is, but I still have to trust you to not discuss the case. All right? Are there any questions about that? But I'm gonna have 2 of you come back. I think you've already ordered your lunch, so I'm hoping the 3 of you ordered something we like. No. Yeah.
My question is, if we're one of the 3 that go home and spend the day at home tomorrow, how do you know? Will you call us as soon and let us know to do the following day?
Absolutely. I feel bad enough that I feel like I kidnapped you. Okay, so I feel bad enough that you're here. I know that you know why. Okay, because you know, when this is all over, I'll tell you stories about strange things that happen and jurors and, you know, just life happens. So As you know, this is a very long, emotional, and frankly expensive process. To start over would be devastating for everyone in the room. So I appreciate you. I feel bad, but I would feel worse if we didn't have enough jurors to finish deliberations. Okay, so 3 of you, I'm gonna pick three numbers by blind draw, and then you can exit, and they're gonna take you down to your car. And we have your phone numbers. You are still sequestered, all of you, and the other 2 have to return back in the morning. Okay. And I'm going to tell you again that during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they can give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. So do not go on social media, don't post anything, don't go on Facebook, don't do research, don't discuss the case with anyone.
Don't watch
whether
YouTube.
you're at home or at work or here spending the day with me again. All right. So I'm going to pick 3 of you by blind draw, and the other 2 have to return at 9 o'clock in the morning. All right.
Your Honor, whoever it is that is coughing in the gallery needs to go home. They need to go home. They're coughing into the microphone. It's making me feel sick.
All right. Juror 17. You can be sequestered at home. Juror in seat 4. You can be sequestered at home. And juror in seat 10. 10. You can be sequestered at home. All right. You can bring things with you. You're 9 and 15. Jurors in seat 9 and 15. I mean, obviously you can't bring a newspaper or something like that. You still can't research the case. But if you have work, you can finish my crocheting for me. If you know how to crochet, anything like that. I know it has to be really boring, but I think you understand the purpose. You can't talk to anybody. Again, a lot of people here would love to talk to you, but none of you are allowed to talk to the press or discuss the case with anyone. All right? And we do have your phone numbers. So I'm going to release you to go back to Judge Anderson's jury room, and then you're going to be escorted out of the building. And then the 2 remaining jurors, if you could come here at 9 o'clock tomorrow morning. All right? Any questions about that? Okay, we appreciate you. Thank you for understanding.
All rise for the jury.
Wait, so I missed what you just said because I was laughing at this comment from Kate McGuire. Does anyone else here wish Melanie was their mom and sister and BFF? Type 1. Did she just send them home? Because they're on Eastern time, so it's 4:45 p.m. there. Did she send everyone home or just the alternates?
Okay, now I'm going to bring another jury, and if you can all be seated.
Ricola. Ricola. Law and Crime Trial Channel brought to you by Ricola. For those times when you just can't stop coughing in court and annoy every single person who's trying to watch this on YouTube. Scott, I'm trying to get Vinnie Politan to let me be his partner so we could like do a show together. Wouldn't that be fun?
You come back tomorrow morning, what time is it? 9 o'clock?
Do we like 9?
9 is good.
9 o'clock? Okay, you're gonna return tomorrow at 9 o'clock. We appreciate your efforts. We appreciate you taking this seriously. This is very serious, as you know. And I need to tell you that during the trial, do not read, listen to, watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they will give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Do not go on social media, don't post, don't go on Facebook, don't do research, don't discuss the case with anyone. All right? Any questions about the schedule? We'll be kind of at your will, so get a good night's sleep, maybe sleeping on it will help you, right? Stay healthy, we appreciate you, and we'll see you at 9 o'clock.
We appreciate you.
All action adjourned.
Stay away from YouTube and LawTube, especially because those people do not know what they're talking about. And we do not want you to be unduly influenced by such lawyers who would dare to have a YouTube show and talk about their opinions and what has been proven and what hasn't.
Honestly, but simply be wrong about what they thought they saw or remember.
All right, that's the end of that. So the jury went home. They're coming back tomorrow at 9 a.m. They were pushing for 10, but then somebody said 9. So they're coming back at 9. And yes, she has been in jail for 2 years, and she's in solitary 23 hours a day. I need some more information on that. I have questions. Did they not set bail? Are they holding her without bail? Could she not make bail? She's been in solitary since December 4th of 2021. For someone who's been in solitary confinement 23 hours a day for over 2 years, she is remarkably well-spoken on the stand. I can't even imagine how crazy I would be after one weekend of solitary confinement. They set bail and she couldn't pay. I mean, my friends, can we, wait, I guess I got to get rid of the other poll before we can do another poll. I don't even know if we're still on the Ouija board poll. Let me see what the results of that poll are. Should a woman like this be held without bail for 2 years? All right. Do you think allowing your kid to use a Ouija board is bad parenting? 72% of you said no. 28% of you said yes. So that's where we stand on that question. And I was just really curious about that. It was high bail because they thought she was fleeing. Yeah, they're saying she was close to the Canadian border, but like she says that they were just fleeing from the media. They just want to try to get some sleep before they were going to turn themselves in. Is she a violent criminal that rises to the level of being someone? Listen, I'm from New York. Everybody here gets out on bail. You know, like Kevin Porter Jr., that basketball player who had something like an $85 million contract with, what was his team again, Scott? The Hornets. Beat the crap out of his girlfriend, choked her, may or may not have broken her neck, and just walked out of jail with a come back in October card. And now he's going to plead to a misdemeanor and go to 26 weeks of counseling, and it's all good. So in New York, we just let everybody go free. This blows my mind that she's in solitary for 2 years and she's not a violent criminal. I mean, just because her son is a violent, psychopathic, evil criminal doesn't make her one. I got problems with this. Canada is your sister state. Yeah. So I submit to you that if she wanted to go to Canada, if she wanted to flee, she would have. I don't know. I think this is a little bit harsh. Yeah, Kellen, you can assault police officers and get no bail in New York, and it can be on video. It can be on video. And on your way out, you get a free prepaid Visa card and a bus ticket to go anywhere you want. Sorry, I'll get off my soapbox. Welcome to my TED Talk. Solitary for her safety? Okay. I still think that's unusually harsh. There are people that are on house arrest who have done far more violent things than she is alleged to have done. Shame on Michigan, Sharon. I agree with you. Shame on Michigan. Barbara says, I just don't think she deserves to spend 60 years in prison for what her son did. We have a split decision on this. We have a lot of people in the chat, and we're very welcoming to both sides here. We have a lot of people in the chat who think that she should absolutely 100% do not pass go to jail. She let her son play with a Ouija board, and that should have been the first indication that he was a psychopath. And then there are those of us who say, we can't judge her parenting. Her parenting did not rise to the level of being criminal. And if it does, then this is a very slippery slope for parents everywhere. And then we have a lot of people like myself who say, I don't even know what to think. I'm on the fence here. I have no idea what to think. So what say you? My peeps, what say you? Aside from the fact that this judge is definitely a Seinfeld low talker. I'm going to go to some of the chats that I starred earlier. And thank you again. Snazzy Trinkets Jewelry for your $5 super chat. Double-edged sword. School has right to search kids' lockers and backpacks, but have immunity when they don't. K-Pick, he has seen numerous doctors after this happened. Not one has diagnosed him with anything yet. But the parents were supposed to know, make it make sense. I'm having a problem with that too. Corporal, there aren't strict laws for guns around teens either. Oh, responding to USA Kiwi, who is, I believe, from down under. Yes, USA Kiwi, I'm shocked. Jennifer, to this day, says she wouldn't do anything different. I think if you look at the video of the parents when they were in the police interrogation room right after this happened, she did say a couple of times, I wish we had taken him home. I wish we had taken him home. But I think for her to say I would have done something differently, as in it could be an admission of guilt and it might backfire against her. So I think she had to tread very carefully about what she said. It was risky for her to get on the stand in the first place, but I really think she had to get on the stand. I think the jury needed to hear from her. Hi, Linda Vergata. How about when he verbally told told them he wanted help, and they supposedly told him to man up and disregard it? I'm still very confused. Can't decide. Yeah, I don't know that he did. It was in the journal that he said that he did, and it was in text messages to other people that he said that he did. I don't know. Mom says he didn't. Marie, we wouldn't be throwing them into jail for all those things you mentioned, but for not getting her child mental health help and obviously not securing their guns. If they were secured, 4 wouldn't be dead. Marie, what if he figured out the combination? What if they were secured and he figured out the combination? I think these are questions of fact that the jury is going to have to decide, and they're going to have to decide whether or not that gun was locked up. She says it was. There's testimony from some law enforcement that searched the house after. They're going to have to come to the determination, and the jury is the finder of fact, whether or not that gun was locked up. She says it was. K Music Taylor, oh dear, the hideous secrets kept. Also, my boyfriend's 15-year-old son was murdered in his own home while his dad worked. Never knew son or friends were in possession of gun nor ammunition. Brother and sister knew. I am so sorry, Kay. That is horrific. My prayers go out to your boyfriend and his family. That should never happen to anyone. That's another question that I had during the Miller hearing. So many of these text messages to the friend came out, and Ethan was telling the friend what he was going to do. And I don't think the friend ever told anyone. And that's something that I've always discussed with my kids. If you find out that one of your friends is going to either harm themselves, harm other people, is being abused, is being hurt in any way, always come to me. Always come to me. I'm confused about that. Maybe the friend didn't even think that he was serious. I don't know. But whether you think it's serious or not, make sure your kids know that it's not a laughing matter, and they should come to you if they get messages like this from any of their friends. Scott McGinnis, jury wanted to know that how he got the weapon that day. It was their first jury question. So they have a problem with that too. How did he get it? Was it locked up? Wasn't it? They haven't heard the evidence. SC, has Jennifer had any contact with Ethan? I don't think she's had any contact with him since that day in the police station when he was arrested. That's my understanding. Pila's mom, will federal rules going into effect if she's found guilty? Parents will always be held responsible. Is that where we go from here? I don't know if rules will go into effect, but this will be case law. It'll be on appeals forever. But it could set precedent. It's in my opinion, it's dangerous, but a lot of people think I'm wrong. Island Girl, she comes across so matter of fact and uncaring. Maybe she's a narcissist. Maybe she had outside interests, but does it make her a criminal? I don't know if I can cross over that bridge. Patty G, in my opinion, Ethan was born with psychopathy. Hard to say if parenting would have made any difference. Right. That's what I'm saying too. Even if they had done what everyone in the chat who thinks that she should have done something and taken him home that day and gotten him immediately to a shrink that same day, would that have prevented this course of events from happening? I don't know the answer. But what I learned in the Miller hearing, actually is one hearing, it's in a million parts, is that this kid had a plan and he was going to do this no matter what. I don't know that anybody or anything could have stopped him. Even if he was committed for 90 days, would he have done it when he got out? I don't know. But based on what I saw during that hearing, this kid has deep problems. And he was a manipulator. And even all of these medical experts that have examined him can't find anything wrong with him. So are we to say that his mother should have known? She should have known? I don't know. It's hard. Kiwi, death of a dog, getting tortured and killed baby birds. Yeah, about the baby bird. Did that come into this trial? I'm going to look to the chat on that because the Miller hearing, again, now I'm confusing and I shouldn't have watched it. But in that hearing, there was a lot of very explicit journal entries and text messages about what he did to 5 baby birds. And I don't know that was that was admitted into this trial. Everyone's saying no, it did not. Nope. So let's put all that aside because the mother did not know about his torturing of the baby birds. And so we, as the mirror jury, cannot factor that into our decision. Not in front of the jury. Wicked Sykes, are you from Boston? Yeah, Shari, it just doesn't sound right. She's been in a cell alone 23 hours a day for over 2 years. No baby birds in this trial. Yeah. So, anybody who knows anything about serial killers knows that one of the earliest signs of a serial killer is torturing animals or small animals. Had she known that, would she have acted differently? Yeah. I think so. Yes, the bird was in this trial. He called one Jeffrey. Everyone's saying no birds. Heather, you can search it up on YouTube. Just search up, not right now, but later, Ethan Crumbley Miller hearing. And I think there's a local Detroit station that has it broken down into listen, none of it is easily digestible. And I do not recommend anybody watch it because you cannot unsee what you will see and hear in that hearing. but I think it's the local Detroit station that has it broken up into more digestible pieces of maybe an hour and 15 minutes each. And it's disturbing on a lot of levels. Very, very, very disturbing. Irish Marie says, not a slippery slope if she's found guilty, in my opinion. More parents will hopefully pay attention to their kids instead of letting the schools and the internet raise them. And that's wonderful. And I think that that should happen regardless. And I think that everyone should pay attention to their children. I don't think we need a decision like this. I don't think we need to throw a mother in jail for 60 years to have us learn that lesson. Because then where does it end? Where does it end? I don't know. Yeah, the baby birds were at being an oopsie baby doesn't mean he was unwanted. Yes. And I said this too, Janelle. Thank you for this. In Nevada, you would never be able to get someone into a mental health provider the same day. This was also, remember, post-COVID. Anybody who raised teenagers during the pandemic, raise your hands. During the lockdowns and the school, no school and the social isolation, anybody who tried to find mental health help for a middle schooler or a teenager during the post-COVID times. This was in 2021, but it was still very, very difficult to find help. And then someone in the comments said, but even if she just made some phone calls, it would make a difference. Even if she tried to get him help, you know, would that have made a difference in a juror's mind? That she at least tried to make an appointment for him? I don't think so, because then they'd say, well, but the gun wasn't locked up, but we've really seen no evidence that it was locked up. This is really, I don't know, you guys, I'm a little torn on this. Let's go back to what we were watching earlier with Jesse. Just finish that up because there were a couple that we can finish.
And he asked me where I hid the bullets, and I told him. And then he said that the gun is missing. When I was still at work, and at that point, I love it.
Okay, was there anything unusual about that?
Yeah, he's at that age where it was hard to get "I love yous" back out of him. For me to open my text and just see him randomly saying "I love you" was abnormal for him.
Right. Did you think anything at that point?
No, not right at that point. I think I said text back "I love you too." I don't remember. I believe I did. Yeah.
Okay. And later in the thread, you say, don't do it. So when you hear there's an open shooter at the school, I want to know in your mind, what do you believe is happening?
Well, my husband had called me when I was still at work, and he said there's an active shooter at Oxford High School. I can't get a hold of Ethan. And that's when I opened my phone and I saw the "I love you" text. And then I texted him, "Are you okay?" In the process of it, I was getting my stuff and running out the door, letting my boss know that I had to go to my son's school. It was on 75 when I was trying to get to the exit, that my husband called me and he asked me where I hid the bullets, and I told him. And then he said the gun is missing. So instantly I'm like, oh my gosh, he's got the gun. I didn't actually think he was at the school shooting it. I thought maybe he walked home and got the gun and was in the field by the school. I didn't imagine my son actually going into a school and shooting. And then when we got more updates, I was like, oh my gosh, he's a school shooter. He's going to kill himself, because in my mind, that's what school shooters have done. They've killed themselves after. So I yelled in my talk to text, "Ethan, don't do it," because I thought he was going to kill himself.
And at the end of her testimony on Thursday, Crumbly was emotional.
In some of the messages the prosecution admitted, you say that you failed as a parent. Are you a failure as a parent?
I don't think I'm a failure as a parent, but at that time, I guess I didn't see I felt bad that Ethan was sad at those things, and I guess I don't know, I just felt like I failed somewhere. I don't really know how to describe it. It's just that point in time, I just kind of felt like somewhere I failed.
Do you believe there was anything, do you believe that you knew or had reason to know your son was a danger to anyone else?
No, as a parent, you spend your whole life trying to protect your child from other dangers. You never would think you have to protect your child from harming somebody else. That's what blew my mind. That was the hardest thing I had to stomach, is that my child harmed and killed other people.
And I think that goes to foreseeability. Let me know if you believe her. Would any parent foresee that their child would shoot up a school? I don't think so. I just don't think so. But that's me.
Do you believe there were things you were thinking at the time, I should do this, but I'm not doing it? Do you look back and think that?
No, I don't. I mean, of course I look back after this all happened, and I've asked myself if I would have done anything differently, and I wouldn't have.
If you could change what happened, would you?
Oh, absolutely. I wish he would have killed us instead.
I wish he would have killed us instead. So I'm going to rewind that because a lot of people have been pointing that out, that she said she wouldn't have done anything differently. And I want to get the exact wording of that statement.
From other dangers. You never would think you have to protect your child from harming somebody else. That's what blew my mind. That was the hardest thing I had to stomach, is that my child harmed and killed other people.
Do you believe there were things you were thinking at the time, I should do this, but I'm not doing it? Do you look back and think that?
No, I don't. I mean, of course I look back after this all happened, and I've asked myself if I would have done anything differently, and I wouldn't have.
If you could change what happened, would you?
Oh, absolutely. I wish he would have killed us instead.
Over the last 26 months, has this been stressful for you?
It's been very stressful. Yes,
Have you had a range of emotions?
I've had a lot of emotions.
Are you trying to, do you believe you are the victim here?
Hi, Anne. We did go over the jury instructions at the beginning, but right as soon as we're done with this, in 2 minutes, we're going to go over them again. So if you were late coming in, we are going to look at the jury instructions one more time. And I agree with you. I think that's what they're struggling with. I do not think this is going to be a quick verdict at all.
I don't want to say that I'm a victim, because I do not want to disrespect those families that truly are the victims on this. But we did lose a lot.
So I think the best way to think about this is that, yes, she had an answer for everything, right? Now, is that convenient? Is that suspicious? Perhaps. But remember, it was her job to explain away all of that. And is that not all consistent with her entire story and narrative? If the name of the game is reasonable doubt, does this give jurors pause to say, maybe I'm looking at this a bit differently now? And remember, this case is unprecedented. Not the most straightforward case to prove by the prosecution. But I will tell you this. This was only the direct examination. We have not seen the cross-examination at the time of this recording.
Well, we did, because we went over the cross together during my last live stream on this case. So if you haven't watched it, go back and watch her cross-examination, because I found it to be disturbing. They slut shamed her. They did. I don't like the words, but they did. And I think it's a problem. Give me 2 seconds. Talk amongst yourselves for 1 second. I just got to do one thing on my phone. All right. Like I said, I have 3 sick kids today. So everybody's sick. And that's what happens when you have a lot of kids. All right, let's take a look one more time. Yeah, so Estrella says, so Estrella, so the people who say guilty just don't like her as a person. That's the thing. It's like whether you like her or not, you have to kind of put that aside. And you can like her or not like her, but is she a criminal that should go to jail for 60 years? Lifelong learner sees reasonable doubt. This is a slippery slope, says lifelong learner. All right, let's pull up those jury instructions again. And I find that it's easier to look at them together and for me to read them to you because I found them to be a bit confusing when the judge was reading them, and she was reading them very quickly. And while the jury is going to have them with them in the deliberation room, if we look at them together, it might be a little bit easier to understand. But really, I mean, I've got a law degree and I find these jury instructions to be confusing. So I don't know that I would have approved them. Understand that jury instructions are, in New York, we have what's called the pattern jury instructions, and then we're allowed to kind of tweak them a little bit. They agreed to these instructions. Both sides agreed. I'm sure they had multiple drafts, and these are the instructions that they agreed on. And here they are. Now remember, she is charged with 4 counts of involuntary manslaughter, 1 for each of the victims. And this is the instructions that were read to the jury. In each count, the defendant, remember that in this case, the defendant is Jennifer Crumbley, not Ethan Crumbley. The defendant, Jennifer Crumbley, is charged with the crime of involuntary manslaughter. To prove this charge, the prosecution must show each of the following elements beyond a reasonable doubt. 1, that the defendant caused the death of the victim. That is, that the victim died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. 2, in doing the act that caused the victim's death, the defendant, Jennifer Crumbley, acted in a grossly negligent manner. The prosecutor asserts 2 different theories to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because she failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because she was grossly negligent. Those theories are 2 different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It is not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. In each count, the defendant, Jennifer Crumbley, is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of these elements beyond a reasonable doubt. 1, that the defendant, Jennifer Crumbley, had a legal duty to the victim. The legal duty to be charged here is one that is imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent their minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Number 2, that the defendant knew of the facts that gave rise to the duty. 3, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And 4, that the death of the victim was directly caused by defendant Jennifer Crumbley's failure to perform this duty. That is, that the victim died as the result of defendant Jennifer Crumbley's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. I'm going to break from this for 1 minute to just point out that he's 15 years old. Do you think that she had the ability to control him? If he had these compulsive, impulsive thoughts, and if you didn't watch the Miller hearing, it's all in his journal that he was going to do this no matter what. Didn't come into this trial, so you can't really consider it. But did she have the ability to control him as a 15-year-old boy if he had these impulsive psychopathic thoughts? I don't know the answer. In order to find that the death of the victims was caused by the defendant, you must find beyond a reasonable doubt that her son's act of shooting someone was reasonably foreseeable. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or a failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. 1, that the defendant knew of the danger to another. That is, she knew there was a situation that required her to take ordinary care to avoid injuring another. That the defendant could have avoided injuring another by using ordinary care. And remember, this is the defendant, Jennifer CRUMBLEY. Number 3, the defendant, Jennifer CRUMBLEY, failed to use ordinary care to prevent injuring another when to a reasonable person, it must have been apparent that the result was likely to be serious injury. I think, and this is me, and I have a law degree, and I've been practicing law for 30 years, that the fact that ordinary care is sprinkled throughout here that this is very confusing. Is it ordinary care, or is it willfully disregarding the results to others that might follow from an act or a failure to act? So in order to find the defendant was grossly negligent, you must find each of these three things: that they knew of the danger to another, so that Jennifer CRUMBLEY knew that her son might go shoot a person. Not that he was going to go hunting, not that he was going to go to the shooting range, that she knew that he was going to shoot a person. That the defendant could have avoided injuring, the defendant, Jennifer CRUMBLEY, could have avoided him shooting other people by using ordinary care. I can't get past number 1, that she knew that he was going to shoot a person. What say you, my friends? What say you? You can go back and read those later as well. Lifelong learner, ambiguous at best. Wow. They're going to be in there for a long time, I'm telling you. I am having trouble understanding these instructions. Both sets of attorneys agreed. She did. He wrote in his journal. I don't know what that's referring to, but she did not read his journal. So she doesn't know what his journal, she didn't see the journal until after the shooting, and the journal was in the backpack. So if the school had searched the backpack, they would have found the gun and the journal with all of these disturbing thoughts, and he would have been committed. So Rebecca, I don't think she was a great mother, but it's not against the law to be a bad parent. Nancy, she thought he was going to shoot himself. Yes, I don't think that she thought that he was going to shoot other people. Ordinary care would lock the gun up. I agree. She says the gun was locked. She says the gun was locked. Whether or not the jury believes her, that's up to them. That's a question of fact that they will have to decide. Ethan did not testify because he was going to plead the fifth. Jen, wasn't there reasonable people in the school? Boogeyman, yes. In the journal, the shooter said that he told her, I'm going to submit to you that a psychopath will lie. That a narcissist will lie. Narcissists are liars. Psychopaths are liars. So just because he wrote in the journal that he told her doesn't make it true. That's why I have a problem with those journal entries coming in. She says he never told him. I mean, he never told her. See where I'm going with this? Florida Fun Sun says guilty. A lot of people say guilty. See, we have a very, very split crowd here. A lot of people say guilty. Beach Bree, ordinary care would have been taking him to the emergency room for evaluation for psychiatric admission. Right. So if she did that, then you would say she's not guilty. What if she called to make an appointment for a doctor but couldn't get him in that same day, and then he went back to school the next day and did it anyway? Right? Busing for truth. Ding, ding, ding. Ding, ding, ding. Sushi, they had 2 other guns in the home already, and he never took either one of those to school. I know, but you know who did take guns to school? All the kids that went hunting before school on late start Wednesdays when they didn't start school until 10:30 because there were kids who went hunting before school. So it should have been reasonably foreseeable to the school that almost every kid may have come to school with a gun, and maybe they should have done more to prevent that. That's where I'm having problems. Thank you, Melissa Smith, for your super chat. Blame can be assigned to all of us. Many people could have helped this family. Parenting is hard, and we can all support each other better. Yes. Yes. Are they going to send a woman to jail for 60 years for being a bad parent? I don't know. I think the jury is going to be hung. I don't think they're going to come to a decision. We can't even come to a decision in this chat. Hickory, gee, thanks for your super chat. If she had tried to make an appointment that same day, the prosecution would have said, see, she even knew he needed help and she still let it happen. Could be, yes. Scott McGinnis, thanks again for your super chat. Jennifer Crumbley's high profile has landed her in protective custody, same as TB. Turtle Boy, sheriffs are being better safe than sorry with them. SOP. Thanks, Aaron, for becoming a new member. Patty, I think we looked at this before, but I agree with you. So I'm coming up yet. In my opinion, Ethan was born with psychopathy. Hard to say if parenting would have made any difference. I know. I agree. That's where I'm having a hard time. Kellen, hello, Kellen. Will there be appellate issues since her son was prosecuted as an adult, but she's being prosecuted for that her minor did? Thanks again. No, because in the Miller hearing, they specifically said it's okay for us. It's okay for you to sentence him as an adult and for us to then go after the parents. So apparently there is no appellate issue in Michigan on this. Kaylin, we seriously can't judge a woman because she wasn't able to stay home. Suzanne, in the Miller hearings, he mentioned to the psychologist he was waiting for someone to take away his gun and stop him. I think if mom hugged him that day at school, it may have changed something. Suzanne, don't watch the Miller hearing. Oh, you did. You did watch them. This is regarding that. I don't know. I read those journal entries too, and I wish I didn't. But it seems like he was hell-bent on doing this no matter what. There was nobody that was going to stop him. I don't know. I think it's hard for any of us to hypothesize about what he would or would not have done. And that's why I have such a hard time with this. People are convicting via emotion, not law. You're right. And it's hard to take the emotion out of this. And it will be for, 10 women and 2 men that are left on the deliberating jury. Cox, the school didn't know he was seeing demons or that the parents bought them a gun. I talked about this earlier, but I submit to you that the school, when they found him looking at bullets in class the day before, and based on his writings, that they should have assumed that he had a gun. And if they didn't assume, they should have at least asked. Was it up to the parents to volunteer that? I don't know, because it seems like everyone in this school had a gun. They had 2 guns in their house already before they bought him this gun. And I don't know about the seeing demons thing. I think she said that was a long time ago and that he always thought the house was haunted. So I don't know if that was actually demons. Was it actually demons, you guys? Sonny, who hid the bullets? She said she did, but other testimony, her husband was responsible with all related gun items. I don't know. Irish Marie, no one can say if getting him help wouldn't have made a difference. No one will know because he didn't get help. Right. One can fail at something, says Rebecca, yet it doesn't mean he or she is a failure. Don't make an identity for oneself out of it. Doesn't define one at the deepest level. This is a tough one, my friends. This is a tough one. D, my kids got their backpacks checked for a whole lot worse. Yeah, they said if they thought he had a vape, they would have checked his backpack. That's, I'm having a problem with that. Smitty D, how many teenage boys want their moms to hug them at school? My 16-year-old will hug me all day at home, or if he initiates it, he still doesn't want me to hug back in public. Jamie says there was no evidence on how he got the gun. Yes, Jules, I think we'll leave it here. This is a sad situation, no matter how you look at it. Kate. Instead, we'll end with Kate McGuire's comment. Let me get this right. She's innocent until proven guilty, yet without being proven guilty, she is still guilty enough to be imprisoned and shackled and kept from her minor child. Yeah. She's been in solitary confinement 23 hours a day for 2 years because she couldn't make bail. She's not on house arrest like a lot of people here. Oh, is Uncivil live right now? All right, I'll let you go. I'll send you over there. Is he live right now? He never invites me on his channel. He's been on my channel several times, but he doesn't invite me. So I can redirect you guys over there if he's live right now. Tell me if he's live. Hi, Olivia Benson. How are you? We need to catch up, girl. We can't blame the government. We can't blame the gun. We can't blame the parents. So are we going to blame the kids? How far are people willing to go for a weapon? St. Jenny says, yes, he stated in text messages not long before the shooting that he was seeing demons. Yes, he's live. He's on live like every 6 hours a day. But he doesn't invite me, so. But I'm going to redirect you over there. So when you get redirected over there, let's do this. Tell him Melanie sent us, and she wants to know why you never invite her on your show. He claims it's because he uses some other thing than StreamYard, OBS or some crap like that. But, you know, I don't know. I'm just kidding. You don't have to give him a hard time. But at least tell him that, that I sent you. So let's say. All right, my friends, it's been really fun spending my afternoon with you. Thank you, Paul Youngs, for gifting a membership. I thought I would entertain you while the verdict watch was happening because, you know, sometimes I like to bounce around. I like to bounce around. Cupcake invasion to Kurt, okay? I like to bounce around, and I know you'd rather stay with me, but it's already been 2.5 hours, and I have 3 sick kids, so I got to go pay some attention to my children's. Yes, thank you, Anne, for liking this community. My preferred true crime group altogether. Great mods, cordial and respectful chat conversations, much appreciated. Thank you. My mods are amazing. They are the best. I love them to death. Thank you. I see Patronus Glow is here. Peter and Rochella are here. Scott's here. Cheryl's here. All of my amazing mods who keep the chat classy. And Scott has to go make dinner anyway, so I'm going to let you go because I know you eat like early dinner. So remember, as I always say, thank you, Patronus Glow. Please hit the like button on your way out. Please subscribe. Please hit the notification bell because a lot of you aren't getting notifications. And sometimes I plan it a half an hour in advance. So you don't want to miss out because we do have a lot of fun here. We really do. Thank you for sharing your thoughts with me. Please be respectful in the comments. Keep it classy. And remember, everyone, be cool, be kind, be classy. It is not hard. It is so not hard. Peace. I'll see you real soon.